Michael Anderson has been director since 1988 of the Natural Resources Secretariat of the Manitoba Keewatinowi Okimakanak, which represents Northern Manitoba First Nations. He provides research, policy analysis, and negotiation support and has participated in proceedings before the National Energy Board, Manitoba Public Utilities Board, and the Manitoba Clean Environment Commission, as well as before standing committees of the House of Commons, the Senate, and the Manitoba Legislature. Anderson participated in the development of methodologies for land use, occupancy and habitation studies, traditional knowledge, research, and treaty land entitlement studies. He has also participated in the development of toolkits for First Nations entering into a Crown First Nations consultation and accommodation process. Michael.
I'd like to first thank Elder Bone for the prayer and setting the meeting in a good direction this morning. I'd like to thank Professor Kraft and Commissioner Wilson for hosting this meeting. I'd like to acknowledge our presence today in Treaty 1 territory. It's always a good thing to hear all speakers make reference to our homelands and territory. And when I was talking with Doug, I realized that my landlord is here because I own a piece of property in Fee Simple within Snuneymuxw territory. And so I recall when they sent out the notices for the treaty negotiations, I said, I'd be happy to pay my taxes to the Snuneymuxw Nation. And I want treaty fishing license 001 because it's part of the area that I've worked in protecting. So in thinking about the concepts here, I just wanted to briefly share a couple of other experiences. I know that many years ago when I was part of a conference in White Rock, BC, which is one of the first ones that brought environmentalists and First Nations together, a young Gujau was speaking passionately about Aboriginal title on Haida Gwaii. I also later in that period of time remember a really clear definition of Aboriginal title that was shared with me by former Chief Terry Morgan of Stolo on the Fraser River. And he simply said, the government don't own a spoonful of dirt in this country, and you have to believe it right here. And that was very clear. And so when I think of that coming to Manitoba and beginning to work with the First Nations in the north, late Elder Sandy Beardy would say about the compensation lands that were being proposed under the Northern Flood Agreement, he would say, well, how can you give us back what is already ours? And so those kinds of presences of Keewatinowi, this land is ours, is what grounded all of the work that I've been doing with MKO for the last few years. And I remember that the advice that I was given first by the leadership was, Mike, don't. Always remember that you work for the people and report to the chiefs. So I've hoped since I'm here and gratefully invited to speak with you about this, I'm glad that I've listened to the teachers, and I hope those that have taught me and shared so many ideas with me will see that I've listened today. The discussion that I had wanted to make briefly before I got started was about Tsilhqot'in Nene in the Nunavut settlement area and a claim for unresolved Aboriginal title that exists for two First Nations in Manitoba, Treaty Number 10 and Treaty Number 5. Now, most people think that the treaties settled title to treaty lands within Manitoba or for Manitoba First Nations. But there is a claim for unresolved Aboriginal title by the Northlands Tsilhqot'in First Nation, and Elder Councillor Hislop is with us today, and also for the Saisi Dene Nation of Tuduli Lake. The beginnings of this claim originated when we began to file for a litigation that dealt with the interests of Tsilhqot'in north of the 60th parallel not being taken into account in the Nunavut land claim settlement. We engaged in about a 10-year political and legal campaign at the House of Commons. We were fighting every single piece of litigation related to the Nunavut land claim. We were going to the Senate and the House of Commons. Astoundingly, we had a Commons committee move on the spot after a presentation to ask Minister Sidden not to sign the Nunavut land claim settlement until the interests of Tsilhqot'in were resolved. What triggered the amendment of our initial statement of claim to include a claim for unresolved Aboriginal title was the astounding statement of defense of Canada in which it said that the treaty rights under the terms of Treaty 10 and Treaty 5 existed only within the defined metes and bounds of treaty, not within the area that had been extinguished under the so-called blanket extinguishment clause, but within the specified metes and bounds of treaty. Well, for Treaty 10, for the Northlands Tsilhqot'in First Nation, that would mean that their treaty rights applied only in a tiny sliver of the most northeast region of Saskatchewan. Members of the House of Commons who had recently gone through the process of repatriating the Constitution said, well, that can't be right. We were told that Aboriginal rights are across the country. That just can't be right. But that was the statement of defense. Similarly, in terms of the Treaty 5 lands and interests north of the 60th parallel in southern Keewatin, the position was that Saisi Dene had no treaty rights north of 60. So, working with Arnie Peltz, who was formerly director of the Public Interest Law Center, we reframed the statement of claim and refiled it. And a north of 60 litigation is still officially in place, although in abeyance, pending the outcome of the negotiations of what we call the North of 60 process. The outcome, as a result of the litigation and the unresolved Aboriginal title claim, will result in a completely different relationship with the Northlands Tsilhqot'in First Nation and the Saisi Dene Nation, not only with the government of Nunavut, the territorial government of Nunavut, but with Nunavut Tugavik Incorporated. So that pressing forward with their claim has completely transformed the relationship that these two Tsilhqot'in communities will have. The claim is still live, and whether or not the principles of Tsilhqot'in will apply here in their negotiations is yet to be seen, but in any case, we have a claim in Manitoba. One of the things that I was asked to talk about was strategic implications and considerations for treaty rights to sustenance. And I often describe these rights as a super right. Essentially, the Aboriginal treaty rights to sustenance and food sovereignty, as we would describe it, are at the core of the treaty relationship and the exercise of the honor of the Crown. The Aboriginal treaty rights to sustenance and food sovereignty have been repeatedly reinforced and revigorated in the dealings between First Nations and the Crown in Manitoba, and I wanted to talk about some of those examples. This is a map of the political boundary of the MKO territory. Similar to the map that I began with, the 30 First Nations of MKO's territory extend into Saskatchewan, the Northwest Territories, Nunavut, and Northwest Ontario. But it's approximately 3/4 of the political boundaries of the province of Manitoba. 65,000 Treaty First Nation citizens and 30 First Nations speaking three major languages, so Ojibwe, Cree, and Tsilhqot'in. Each of the 30 First Nations affiliated with MKO exercised food sovereignty at the time of entering into terms of treaties with Canada. The Crown gave assurances that the Treaty First Nations would exercise food sovereignty for as long as the sun shines, the grass grows, and the waters flow. Now, when we met with the Special Rapporteur on the right to food, which was represented, MK was represented by Elder Darcy Linklater, and thank you again, Darcy, for that intervention. Our presentation was that food sovereignty speaks to the right of MKO First Nations to sustainably meet our food needs in accordance with our customary food preferences and harvesting practices, and from within our ancestral lands and traditional territories. This definition is part of the international definition that has been codified by La Via Campesina, and it's similar to the thinking that we have about the basic linkages between land and food supply and Indigenous peoples. This right to food sovereignty also includes the effective exercise of the duty of stewardship, because clearly the lands have to be productive, the animals have to be in balance, plants have to be healthy and growing. And so the food sovereignty can simply not be achieved without stewardship of the lands and resources related to it. The diets and health of the MKO First Nations have been demonstrably and adversely affected as a result of the erosion of food sovereignty arising from shifts in land use authorized by the Crown. These adverse effects on food sovereignty have occurred without having obtained the free prior informed consent of the MKO First Nations, and certainly without having engaged MKO First Nations in a process of consultation and accommodation. The shift in land use includes loss or reduction of formerly productive lands and waters resulting from environmental impacts to and contamination of waters and lands caused by hydroelectric and water control projects, which is probably the largest landscape issue in Manitoba. Mining projects. Manitoba has had mining projects extensively engaged in for at least 86 years. In one region of our province, one company, now known as Hud Bay Minerals, but former Hudson Bay Mining and Smelting, has operated for 86 years. They've developed 26 mines, and they've extracted 145 million tons of ore from one area alone within our province. Forestry activity, urbanization, agriculturalization in some of our areas in the south, the development of parks and protected areas, which is not always good news for us, and infrastructure projects. Now I'm going to borrow a bit from a presentation that I made to the Assembly of First Nations Safety and Security Conference because it's about the same sorts of ideas. In terms of safety and security, these impacts that I was describing, these are leftover tailings impoundments taken from satellite images and that are held by Hudson Bay Mining and Smelting and the abandoned companies that were in the region. And you can see that they're quite extensive, straddling the Saskatchewan and Manitoba boundary. Also, we have considerable contamination throughout our territory caused by airborne deposition of heavy metals from our mines. It's not unique perhaps to our territory, but in many of the regions of the province, especially the two regions affected by airborne deposition of lead, arsenic, cadmium, and so forth from our larger mining operations at Flin Flon and Thompson, the organ meats of game animals are toxic, are not supposed to be eaten in any quantity. And organ meats are a source of vitamins in a traditional diet. They're very important. So we have lost the ability, it's affecting food sovereignty not to be able to engage in eating all of the parts, the gifts of animals that provide nutrients and medicines. One of the teachings that's been shared with me is that many animals will convert plants that are toxic to human beings into medicines by eating the animal that's eaten the plant. And so with this kind of toxification of animal organ meat, it removes that medicine as a source of health for First Nations. The basic requirements are also affected by extensive logging that's taken place within our territory in very large patches in areas of the boreal forest, which are strongly affected in areas with our very slow growth of our northern boreal trees. Means that while at some point these might be good habitat for moose and other ungulates, it'll take a very long time to get it there. So these large patch clearings have a substantial impact on food sovereignty. Hydro projects, as I've described, are the largest changes in our landscape. This is GenPeg. Many of you have GenPeg's been in the news recently, the occupation of Okimakanak of the facilities. If we look at this picture, you see a V in the center. The generating station is on the left of the V, and the control structure is on the right. They span an island. The control structure on the right controls Lake Winnipeg and has lifted the level of the lake by 4 feet and provides the primary water storage for the downstream flows on the Nelson River in conjunction with the Churchill River diversion, which controls the waters of the Churchill River and southern Indian Lake. This is Ovid's home territory. This is the Grand Rapids generating station. And if you look at this small U along the bottom here, this is actually the dewatered riverbed of the former Grand Rapids. So what they call the spillway channel is actually the river. You can walk on the bottom of the dewatered river. All of this has enormously affected the ability to produce food in this region. The former Saskatchewan River region, and I'll talk about that in a minute, had what would have amounted to an interior salmon run. Millions of whitefish came through these rapids every year to spawn in Cedar Lake. And as a result of the building of the dam, that fishery was virtually wiped out. They also say that the species of whitefish that traveled through the rapids to spawn in Cedar Lake were not the same ones they're catching today. Fishermen call them humpback whitefish. And I was given one to have it genetically tested by Freshwater Institute, and they are completely different fish. They have a very large forebody. They weigh considerably more, and they're much better to eat, which was why it was so hard for me to get one to have it tested, because usually if the fishers actually catch one, they take it home right away. In addition to that, we can see the earliest plant, the large dam on the Nelson River. This is at the Kettle generating station. This is the upstream forebay of Kettle. The area that's in black hatching is the current reservoir surface. The area that's in white marked Nelson River was the original river channel. So we can see, if those of you that are familiar with boreal forest and riverine environments would recognize that as an immensely rich habitat for the production of game and fish and for other products, for medicines along the shorelines and so on, all of which was completely buried by the construction of the Kettle generating station and the creation of a very large and unnatural lake at this site. So these are all the sorts of things that we're dealing with in our region, and the so what of it, in terms of the context of a case like Keewatin, is that where it leads us is here. So when we talk about concepts in Keewatin about no meaningful exercise of the right, in Manitoba we're way past that threshold. That's what I'm trying to get at. So in terms of where our focus is on our work and research, and why I wanted to talk a bit about how food sovereignty fits into this, we already have areas where we can't hunt at all. Now this, interestingly, is a co-management arrangement, which is one of the most successful that's been conducted in Manitoba. The Swampy Cree Tribal Council and the Opaskwayak Cree Nation in particular recognized that there would be no harvesting of moose at all for domestic use, for food, unless they cooperated with the Department of Natural Resources and the local communities and created a voluntary ban on the harvesting of moose. Now this was successful enough to bring a ban into a harvestable surplus of 100 animals when they reopened the harvest, and the relationship that was established with the province allowed for OCN, Opaskwayak Cree Nation, to determine what the allocation would be in the original licenses. So it wasn't, even though all 100 moose could be easily consumed under the treaty right by the Opaskwayak Cree Nation, they allocated 30 licenses to non-Aboriginal hunting. So they were beginning to allocate and manage this region. But in any case, the combined effect of logging and road development and over-harvesting have resulted in this kind of crisis in moose harvesting occurring again down in southwest Manitoba, north of Riding Mountain this year, where there's another closure for the hunting of elk and other animals. So these are very serious issues that we have to address, because this concept that no meaningful exercise of the harvesting right will happen at some point in the future, we're way past it here. In NCN territory, the Nissequawsik Cree Nation, before the building of the dams, you could close your eyes, take a cup, take a scoop of water and drink it without looking. Now the water is the color of tea with cream in it. And the fish that are in the river, the elders and others say, are unpalatable. They're soft, they're squishy. They're not the same texture and firmness that the fish that swam and grew in those clean waters. And so we're now looking at having to measure how to establish this, because the concept of the honor of the Crown and the upholding of the rights promised during treaty is not a diminishing dot of being able to exercise rights on whatever land is left over after all the mining and hydro development and forestry and urbanization and agriculturalization. The arrangement was to share the entire land base, and to do it in such a way that the exercise of food sovereignty could be maintained throughout the land base. And so this is the critical point in law that we're now looking at, because that standard set in Keewatin, we are way past, and so we need to be working on that. Now, if I look at several elements of our recognition of food sovereignty in northern Manitoba, another story for me, and something that very strongly was impressed on my mind, is I remember being in a meeting in Tsilhqot'in, and an older fellow, a trapper who was very active on the ground with his wife, was sitting in a meeting, listening to government explain a plan for the management of trap lines and resources. The trapper very politely listened throughout the entire meeting, the beaver cat folded neatly in his cap, and at the end of the meeting stood up and said, "You need my consent before you come in my trap line." And then went to the side and got some of the hospitality and a cup of tea, and he and his wife left. Well, what impressed me very deeply about this is that this trapper and his wife, his family, believed that that statement was absolutely determinative. Absolutely believed it. And for my beginning experiences within the MKO region, I heard this same message meeting after meeting, community after community. The citizens in the community would greet the government with their phone cord boards about how to protect moose and caribou, and so on and so forth, with the same comment: "You need my consent before you come into my trap line." As a group of trappers, they would say, "You need our consent before you come into our territory." And so this concept of access, I wanted to try to sort out exactly where this was coming from, because of course the government people would always take me to the side and explain that they don't know what they're talking about. They don't understand. But in fact, the Cree of northern Manitoba and the Tsilhqot'in and the Ojibwe Cree have lived largely undisturbed in the areas that are not directly affected by industrial development since long before Europeans came to Canada. And so what we're actually hearing is the customary law. And I have been grateful to be taught by my brother Darcy Linklater about the customary law of treaty, and my friend Ovid. And about the law is in our languages, is in the languages spoken in the area, and what was being expressed in all these meetings was the law. So when we look at the root of it, we see, in addition to the international, we see that the objective is Medo Pimatasiwan, which is living a good life, and May had mentioned this before. But just the very siting of all of our communities has all of these core and critical elements to them. So the fact that there is a village or a community or a long-term settlement means that there's a balance of water, food, fuel, shelter, transportation and networks, spiritual sites, and physical security. These are very carefully chosen spots by the ancestors. And so these are places from which the negotiations took place, that food sovereignty was a critical element of it. In terms of the treaties themselves, of course, the terms of Treaty Number 5, which are very similar to the other treaties in Western Canada, said that Her Majesty further agrees with her said Indians that they, the said Indians, shall have the right to pursue their avocations of hunting and fishing throughout the tracts surrendered as hereinbefore described, subject to such regulations as from time to time may be made by her government of her Dominion of Canada, which the courts have described as largely related to conservation, to protect the supply of food, and saving and accepting such tracts as may be from time to time required or taken up for settlement, mining, lumbering, and other purposes. Well, we can see that the other half of the treaty partnership in Manitoba has enjoyed the benefits of the treaty by taking up an enormous amount of land. But the opposite side, to protect food sovereignty and the beginning of this promise, has clearly not been met. The honor of the Crown has not been upheld in respect of food sovereignty in Manitoba. Some things that people may not be aware of that I wanted to share with you, and if you look at the bottom of this little extract that I've taken from a document from the National Archives, in 1890 there was actually a special fact finder, James Wilmot, who came to Lake Winnipeg to study the fishery. Apparently there were complaints by non-Aboriginal fishers of extensive, and I think it's indiscriminate is the word that's used in the upper part of this document, Indian fishing. But actually one of the things that he was here to look at is whether Lake Winnipeg should in whole or in part be dedicated as an exclusive Indigenous Aboriginal fishery. And at the bottom he says, one of the questions he reports to Parliament, should any and which waters be reserved for the exclusive use of Indians? Yes. And he basically says those areas on the reserves and surrounding the lands where the people must have access to fish for food, set it aside. Well, this is in 1890. They were already fretting about the conflict between settlers and First Nations for the supply of food to First Peoples. The Manitoba Natural Resources Agreement 1930 has some pretty powerful words, and it's recognized as a constitutional obligation. In order to secure to Indians of the province the continuance of the supply of game and fish for their support and subsistence. Canada agrees the laws respecting game enforced in the province from time to time shall apply to the Indians within the boundaries thereof, provided that the said Indians shall have the right, which the province hereby assures to them, of hunting, trapping, and fishing game and fish for food at all seasons of the year on all unoccupied Crown lands and on any other lands to which the said Indians may have a right of access. Well, we, of course, disagree to the chain of reasoning in Horseman and Badger. And Professor Brian Schwartz came to a conference that we held on the NRTA and gave us a presentation with a lovely title, They Got It Wrong. The point is, this is presently the constitutional law of Canada, and it's all about food in order to assure the continuance of supply. And so again, this trapper and his family and the others saying, you need our consent, it's all coming from here. These recognition of these rights to harvest. Another important one is the establishment of the Manitoba Registered Trapline System in the 1940s, with the agreement finally signed in 1949. The original agreement recognized the province further guarantees to the Indian trapper his traditional practice of group or family operation of the new registered trapline as previously enjoyed on the trapping ground of his own selection before government control of trapping areas was imposed. So at the time that the registered trapline system was created, they were also talking about setting aside Manitoba north of the 55th parallel for the sole use of the Indians living there. So we have these continuous references to exclusivity, sole use, setting aside lands in respect of the treaty policy. And so when our trappers are in their meetings saying, you need our consent, this is our land, it's what the government has been saying all this time. Now, if we look at the trapline boundaries that were originally made, this is a rough map of the initial registered trapline sections created in northern Manitoba. They actually followed, I interviewed several of the elderly government officials who actually went to the communities, and I've been given the honor of being a caretaker for some original maps from the Matthias Colomb Cree Nation that were made during this time. And the maps that they were using were Dominion survey maps of the Government of Canada. They would bring them into the community and ask people to mark out where they use the land. It's very similar in its core elements to a lot of the modern traditional land use studies, very similar to the one that we use. So I was just electrified when I looked at these maps with all of these neatly drawn single-line boundaries with their names in syllabics in the center on all of these maps. The one for Puckatawagan, though, was generalized and had a one single-line boundary around the outside on the original Lands Branch blueprint, and all it said in the middle was Puckatawagan Indian Grounds. It wasn't subdivided, wasn't broken up. It recognized the family use of trap lines and created this current system. The other powerful statement, which is enormously powerful, and our friends from Pimachikamak will recognize this, this is a treaty, and I'll talk about that in a minute. Article 15.1 of the Northern Flood Agreement, which affected 5 First Nations affected by the large-scale flooding in Manitoba. Manitoba agrees to grant to the residents of the reserves first priority. Now, I stopped for a minute because that's the language of the Supreme Court of Canada in Sparrow. First priority to all the wildlife resources within their trapline zones and in the rivers and lakes which are traditionally available to and used by them as a source of food supply. Here's this exclusivity and priority for food again. Income in kind and income. Now, for those of you that are NRTA students, it appears the province has granted back the commercial right in Article 15.1 of the Northern Flood Agreement. Very critical. Only one First Nation still holds this original provision, and that's Cross Lake or Pimachikamak. Article 15.3, though, goes even further. Manitoba has encouraged and will continue to encourage the residents of reserves to achieve the maximum degree of self-sustenance and food supplies, food sovereignty, and to maximize the opportunity to earn income and income in kind from wildlife resources, commercial harvesting again, and will therefore prohibit hunting, trapping, and fishing in the resource area by any non-resident of the reserve who does not have a present right at law to carry on these activities in the resource area. Now, the Northern Flood Agreement was signed on December 16th, 1977. So anybody whose permits have lapsed since then, in theory, the area is exclusively used by Pimachikamak, who is the last remaining of the five original NFA First Nations. So the point is, this is not a historical document. This is the Northern Flood Agreement. It's existing today. And on December 15th, 2000, the Minister of Aboriginal Affairs, the Honourable Eric Robinson, who's the Deputy Premier and Minister of Aboriginal Northern Affairs, said, "I'm rising today, Mr. Speaker, to report that this is only the beginning of our government's efforts. We intend to move forward immediately in the following ways. For the first time in the history of this House, the government of Manitoba recognizes the Northern Flood Agreement is a modern-day treaty." So all the provisions I just read you about top priority and exclusive use are now given the weight of treaty by the government of Manitoba, and expresses its commitment to honor and properly implement the terms of the Northern Flood Agreement as recommended by the Commissioners of the Aboriginal Justice Inquiry in 1991. So, in essence, when we look at the tools that we have this enormous impact that's pushed us way past the concept of no meaningful exercise, counterbalanced with a very long history of First Nations harvesters and resource users, hunters, being told, this is your land. You have exclusive use to this land. And not only that, in some cases, the other people that are not residents of the reserve will be prohibited from harvesting and interfering in hunts in your territory. So against this backdrop, we're trying to create the tools, which is actually what I was initially intended to be doing. The Natural Resources Secretariat was developed by the Chiefs in Assembly in 1988, basically to try to do a lot of the kind of work that's being done in support of the litigation that we're seeing around us today. We had satellite imaging capability and geomatics capacity even before the Government of Canada and the province in some areas had. The First Nations leadership basically took the view that the eye in the sky doesn't lie, and it's very difficult to track and monitor activity over 3/4 of the modern-day province of Manitoba. So these are all the tools, and the one that I've talked about many of these, but the first one I wanted just to talk about is maintain presence on the land. Critical. There were large forest fires in 1989 that took out over 3 million acres of land. We became very concerned because we realized that from our narratives that there were almost 200 camps, cabins, and fishing establishments, traditional harvesting locations that were destroyed by the fire. We negotiated $1.7 million in compensation, flew over 3/4 of the province, and replaced the cabins. And the reason for it, and I'll conclude with these pictures that I have here, is that if you put a dollar value to the in-kind harvest, that is the game and fish and plants harvested in association with commercial harvesting within the MKO region alone, it's valued at conservatively $35 to $50 million a year. Now, the commercial returns that are driving this harvesting activity are only about 14 million when you combine commercial fishing and trapping together. So it means the commercial activities are literally underwriting the cost of harvesting domestic food for bringing back to the house. And so it's critical that harvesters remain on the land and have access to the land to bring these values back to the community, whether it's for medicines, for berries, for building materials, fish, or game. The pattern of activity is year-round. It's something else to document. The thinking here is that our land use activities have to be visible. And that's something that we've learned from Tsilhqot'in, that in terms of the work of bringing Justice Vickers out onto the ground to have him see with his own eyes where the people were using the land and how it was being used. This is an old table that I developed shortly after the Sparrow decision, and Ovid and others might recognize it. This actually was shot off an overhead. But the concept is to really press for balancing these rights, powers, and privileges that the regulatory mechanism in Sparrow creates. It creates a layer cake for managing fish and game. The first layer is the government's duty to maintain populations for conservation purposes, to maintain the conservation minimum. All fish and wildlife surplus of the conservation minimums are available to basic harvest of First Nations in accordance with their right, literally to when the people are full. And it's only after the basic need, as it's been described in the West, is met, can sport and commercial licenses legally be issued. These are powerful checks and balances on government action. And our belief is that this process needs to be done lake by lake, river by river, stream by stream throughout our territory, so that the needs of the people are met in accordance with their right. Our friends from British Columbia have reminded me many times, need is not a number, but it's the concept of ensuring that the needs of the people are met first. And in exercising food sovereignty, it's important to use it as a tool because it's measurable. I was just talking about basic need. It can be monitored. Mitigation and accommodation measures can be designed. I'm looking at, for example, the decision in West Moberly on the caribou management plans. Shortfalls and expropriations can be calculated. It's important because Sparrow used that term. In the case of an expropriation, compensation may be due. And therefore, you can compensate. You can calculate the compensation. So, as it's been explained to me, when there's sturgeon fishing closures on the Nelson River, somebody owes me some money. The point of it is that the community is not receiving the volume of sturgeon that a healthy and intact river system would be able to produce. That's a shortfall. It's contrary to the right. And compensation is due because it's a de facto expropriation of the right by the hydro stations and other activities that have taken place. And then the other is, of course, document traditional land use and your traditional knowledge. This is actually a map of the coverage of the Natural Resources Secretariat in the mid-1990s. We have considerably greater coverage now. So all of these tools together help to give life to the treaty relationship and keep us all very busy trying to make those rights work for us against the counterweight of all of the impacts and violations and the failure of the Crown to uphold the honor of the Crown for all of this time. And with that, I thank everyone for their patience in letting me run on longer than my wave. And thank you for being here at the end. I was very deeply honored to be asked to speak with such knowledgeable and eminent persons and to share this afternoon with all of you here. I'm very grateful. Thank you.